Hello, welcome. We specialize in comprehensive retirement planning with asset preservation, tax, and retirement services. We are committed to educating our clients with an enjoyable experience, concentrating on all areas of retirement, including Social Security, tax and income planning, wealth management, estate planning, and all other areas of insurance.
Our clients take pleasure in having a team of professionals coordinate a comprehensive financial plan that suits their current lifestyle and helps them to maintain their standard of living.
Our goal is to educate and add value first. We then create a retirement plan that matches up with your goals.
We will do our homework to get to know you and your lifestyle. With our advanced tax and financial software, we can give you a clear picture of where you are headed financially.
Whether you are single, married, widowed, or divorced, we can inform you about the best ways to make the best decision in the most efficient manner possible. As advisors, we draw upon a broad range of knowledge and experience in all areas of expertise, and we are committed to helping you achieve all your retirement goals.
Just a background on asset preservation. The company's been around since 1997. We safely manage over $350 million for our clients, and we're rated A+ with the Better Business Bureau, and we are not affiliated with any other Social Security, the Office of Social Security, or any government agency. This was in the USA Today paper about 2 years ago. It explains on how some estates work through the probate process and how some shouldn't work through the probate process. Everyone's heard of the pop singer Prince. He died back in 2016. The USA Today, as you can follow as I read, instead platoons of lawyers have been working on it for 3 years. Mind you, 3 years since the pop singer passed away. Racking up bills, arguing with one another, arguing with heirs, arguing with consultants. As you'll notice, there's one word that stands out in this paragraph: argue, argue, argue. On various estate matters, filing blizzards of documents and paperwork with the Carver County Probate Court, which has made little progress in its mission to sort out all of this. Now, there's some confusion with most people. They think that when someone says estate plan, they think of a gated community, a big house that's worth 10,000 or that's 10,000 square foot up in the hills somewhere. It's not. Estate planning is for everybody. It's just a matter of whether you do it for your family or not. The main question is a will or a living trust. Before my dad passed away, he brought home a 26-page will and said it was a trust and he was all set. Unfortunately, it was just a last will and testament. It's subject to probate, which means me and my family would be going to probate for my father's assets. So we changed that right away, and not just that, educated my own father the difference between a will and a living trust. When you have a will, all a will is, everybody, is a last will and testament to the court. That's all it is. It's a document that says, here, I passed away. This is where things should go. Unfortunately, it doesn't work that way because the judge or whatever probate judge is probating the estate, he doesn't know who the responsible person is in your family. And we all have one that's in our family that's just not that responsible. So maybe when you pass away, you might be choosing the daughter or the other son, or maybe a brother or sister or cousin or uncle. The bottom line is, though, it's still subject to probate. But quick example, we had a lady, her mom passed away, small little estate plan, maybe worth $80,000, a few $1,000s in the bank. The home wasn't worth more than $80,000 or $90,000, but she still hired an attorney for $1,300. Why? She didn't feel like filing the paperwork, the proper paperwork for the court downtown, or what's worse, the court is open from 9 to 4 o'clock. So if you show up with your paperwork, it doesn't mean they're going to call your case at 10 o'clock. You could be waiting there all day, which is why people hire attorneys. So it's not a bad thing. It's just that they don't want to deal with the probate process. We get it. But when you have a living trust, think of a living trust as a company you set up for your family. I'll use me for example. I don't have children, the wife and I, but we have a lot of nieces and nephews. So if something happens to me and our trust has already been created, if John Lopez passes away, nothing changes. The wife continues the estate plan. But upon second death, once the spouse passes away, now the trust is irrevocable. So there's two words here that are extremely important: revocable and irrevocable. Revocable, while my wife and I are alive, we can change our estate plan as many times as we want to. So when I pass away, like I said before, nothing changes. But once the second person passes away, once that second death takes place, guess what? Now the trust is irrevocable. There are no changes. So what that means is Cousin Vinny from Florida or uncles and aunts from apart in other states of the world, when they come in and say, hey, so-and-so passed away, where's my share? Unless it's in the revocable living trust, which is now irrevocable, those proceeds don't go to them. They can't. Now, just because you have an estate plan done, don't fool yourself. Any estate plan can be sued, okay? Doesn't mean it's perfect, but the court is going to abide by a revocable living trust. All they're really saying is this family's done their homework, so this estate is not probatable. So it's not going to go to probate, so it bypasses all the attorneys and everything else that goes along with it. Why the pop stars have millions of dollars and never, ever think about getting an estate plan, that's a whole nother mystery. That's the major difference between the both of them, court and no court. Me personally, for a lack of better wording, I'm greedy. I don't want the state of Michigan or anybody else in my estate plan, and either should you. So when you work 30, 35 years of your life to build these assets up, I know you don't want anybody else to come into your estate plan and start picking it apart. That's what a living trust does. It's a company. It's ironclad. It says this is the way it's going to be done. Outside opinions don't matter anymore. And then there's the cost. Like I said before, the lady that spent the $1,300 for the attorney, she doesn't want to deal with it. But on larger estates, that number exceeds very high. It's not $1,300. Sometimes it's 3, 4, 5% of a total estate. So if someone's worth $2, $3, $4 million, not saying the average person is worth that, most of our clients have between $500 and $1.5 million in assets. And that includes sometimes the property. So those expenditures can go a lot higher depending on each estate. So it does matter. And then for those of you that have had a living trust done years ago, there's something that came out in 2011 that's a Lady Bird deed. It's just an additional document, that's all it is, that helps keep the estate and the property out of the probate process. Now, unfortunately, there's some estate plans that have been done and the clients don't know what a Lady Bird deed is. So if you had it done in the last 7, 8, 9 years, you don't have it in there, it's something you should look into. There's two types of attorneys though, remember this. There's attorneys and elder law attorneys. Elder law attorneys know about the probate process and everything that's involved, and including Lady Bird deeds. And obviously, the Secure Act has changed a lot too. You can't just give your kids things anymore, give them an IRA and give them these assets and they can cash them out or use them during their lifespan. They now have to cash those assets out after 10 years if they're qualified plans. That creates a problem too. So if you have that in your living trust already and you haven't updated the Secure Act from 2019, that can cause major problems because now they can't just take the IRAs out like the trust or the language in the trust says to spread that money out through your life expectancy. Now they only have 1 decade, 10 years to cash that money out. Again, more taxable issues and problems. So the bottom line today with estate planning, when you have a living will, it is subject to probate. It's just very simple, everybody. These are layman's terms so everybody can understand the difference. Well, we did have one gentleman at one of our workshops that did say, I won't be here, so it doesn't matter. He's right. That is a plan. Unfortunately, it's a bad plan because he is correct. He won't be here to deal with it. It's the kids, it's the family that's behind, that's left behind that says, now what? And then they hire an attorney because they don't know what to do. So our company educates and educates. Now, let me say this foremost, this is most important. We are not attorneys at Asset Preservation, but I am a CRPC, which is a Chartered Retirement Planning Counselor. My job and my designation is to educate you how to pass your assets safely and cleanly to your family. So there is a major difference of getting these things done. Education is great, knowledge is power, but unfortunately, if you don't apply that knowledge to your estate, nothing will ever change. And if you've had an estate plan, how long you've had it, we refer the business out to other attorneys that are elder law attorneys that will look at and pick apart your estate plan to make sure that all the T's are crossed and the I's are dotted. Here's another question that most folks don't understand. Is your trust, once you have a living trust, is it funded? What does that mean, John? That means all funded means, the word funded, is retitling your assets to the estate plan. That's all it is. So if you have a checking, savings, I'll use myself as an example. My wife and I have a checking, a savings, and a money market. Those are things we place in the trust so they avoid the probate. Now there's other issues with IRAs and qualified plans. Some of those won't go into the estate plan. It depends on your estate plan and how you want it set up. And when was the last time you had your estate plan looked at? Just like when you buy windows or a door, or you buy things for your home, most of you will get a second or a third opinion. Just like an estate plan, don't go to the first attorney, get a second or third opinion and make sure it's what you want for your family, your specific needs for your estate plan. And last but not least, what are your plans? And this is important. Does the daughter get the china? Does the son get the gun collection? Understand something, when people pass away, things change. And everybody comes out of the woodwork, unfortunately, looking for their cut. So you want to be specific, and that's why we love Revocable Living Trust, because it's your plan. It's specific and tailored to what you want for your family. It's very simple. We speak from the heart because understand something. When you pass away, it's an emotional decision. And those emotional decisions, now that you're gone, those decisions, they pass on to your children, and they have to make emotional decisions. So if you have the proper documentation, it just makes the process so much easier.